Good evening. I am Jamie Coleman, and I appreciate you all for coming today to hear about estate planning and a mother's legacy as it relates to estate planning. So I'm hoping you can see my screen and we can go through it. And I want to open this up for any questions and answering any questions that you may have too. So um, again. So just a little bit about me. My name is Jamie Coleman, and I am the owner of Coleman Law Firm here in Tallahassee, and I'm also a mom. In fact, I'm an expecting mom. So let me show you a little bump there. But I have a total of four children, and I wanted to have this Mother's Day presentation because I think it's so important as parents to plan for our legacy, which is our children, and protect the wealth that we've acquired. And so often I see too many of our parents, unfortunately, perish, and we don't have a plan for our children. So this is of particular interest and gives me great purpose to do this presentation so that I can explain to you why it's so important to have an estate plan. Your estate plan is not just about, it's not just for the wealthy. It's not about, oh, I don't have enough assets to have an estate plan. Um, an estate plan should be for everyone. If you are 18 years and older, you should have a will. You should have um, documents in place to not only protect your assets when you leave, but also documents in place to protect your assets while you're here. So I want to go through what are the four basic goals that people have when they're talking about their estate plans. Protecting your family is the top one, right? We don't want our families to have to go through um, probate. We don't want them to have to hire a lawyer. So one of the most common goals that I get is I want to protect my family. I want to make sure everything that I've accumulated um, goes to them and not to someone I don't know, like an attorney. Another reason to do estate planning is protecting your asset. So whatever assets you've accumulated during your lifetime, you want to protect them now, but you also want to protect them when you're no longer there, right? So we're talking about acquiring and keeping generational wealth. Another goal is long-term planning. So we don't ever really know what lies ahead, but maybe, sometime down the line, we might develop some type of cognitive impairment like dementia or Alzheimer's, or just memory loss. Having an estate plan protects you it protects you in the long run. So there's a long-term planning aspect of that. So what are the things that you need to do to get your estate or your affairs together? The first thing what I request people to do is figure out, take inventory of everything you own. What are the assets that you own? How do you own them? Okay, that's the first part of developing your estate plan. And believe it or not, we have more than we think we have, right? If you have a bank account, then you need to consider doing some planning. Um, the second thing or step to take is, okay, so now we have inventory of our assets. Let's get a will, a power of attorney, a living will, and a healthcare surrogate together. And then the step three would be arrange your asset ownership to coordinate with your plan. And I'll go into that a little bit more. But you want your plan to make sense as to your wishes, right? I've had a situation where a man had his will, and the will was I give everything to this girlfriend. Um, but all of his life insurance policies and his financial accounts were labeled in such a way that it went to somebody other than the girlfriend. So you really want to make sure your assets are titled in a way, or the beneficiary designations are titled in a way especially when it comes to your financial accounts, that makes sense as to what you want for your estate plan. And so when I'm talking about an estate plan, what am I talking about? I'm really talking about 4 tools. So we've got a toolbox of things that we can use to protect our assets, to protect our families, to make sure that we're planning long term. And one of the tools, the most important, not the most, but the first tool is the will. Okay. The will is basically saying 3 things. It says, how do you want to be buried? It tells me who's going to serve as your personal representative. So who is the person that is going to carry out your wishes? Your personal representative is not necessarily the same person as the beneficiary. And the third thing it does is tells us where do we want our things to go in relation to the people or organizations we care about. So that's your will. That's the only document that really deals with what happens after you pass, right? And it's a tool that you should have in your estate planning toolbox. The second document, which is probably the most important document, is the durable power of attorney. The durable power of attorney says, I trust this person implicitly to handle my financial and my legal matters. Okay. And so essentially, what you're saying is they can make decisions for you regarding your property, they can sign deeds for you, they can sell your property, they can pay your bank. They can pay money from your bank accounts. They can withdraw from your bank accounts. They can write checks. They can file tax returns for you. They can get into your email. They can act like you. Okay. So your power of attorney is so important because while you're of sound mind and sound body, you want to have this document. The alternative to not having a power of attorney is guardianship. And so guardianship is a legal process where you don't know what day it is, you don't know who's in front of you, and your loved ones are worried about your well-being and how to take care and manage your affairs. So they go and hire an attorney for themselves to be appointed as the guardian, and the court then hires an attorney for you to serve for your best interest. And then 3 members of the community come out and examine you to determine whether you have capacity or not. And they draw up reports. And then we all go to court to determine whether you have capacity. And if a court says that you don't have capacity, then they appoint a guardian. And that guardian has to do annual reports and annual plans every year to tell the court how you're doing. And the whole purpose of this is to make sure that your money is not being wasted and that your social and medical needs are being taken care of. And it's a very intense process and a lot of judicial oversight, but it's also very expensive. And so, guess who pays for that? You do, the person that doesn't know what's going on. So, having a power of attorney is a very good alternative to guardianship, but only if you have someone that you trust implicitly to step in your shoes and handle your finances. The other thing about powers of attorney is if it doesn't say that you can do it, then you can't do it. A lot of times I get calls or questions. Well, hey, I want to give this gift I want to deed over their property to myself. Well, if the power of attorney doesn't say that you can deed the property to yourself, you can't do it. You act like a fiduciary when you become a power of attorney for someone. And so that's why it becomes very important that you trust someone implicitly because they can also wipe you out. They can also, take advantage of that power if you choose the wrong person. And so I know you guys got some questions about that, and I definitely want to answer them. So just hold on, and we're going to get through some more tools. So we talked about the will, we talked about the power of attorney. I want to talk to you now about the healthcare surrogate. So the healthcare surrogate is similar to a power of attorney, but it's regarding medical decisions. You're empowering an agent to help you make medical decisions. They get your medical records, they talk to your physicians. And so that's a role that's different from your financial and legal matters. They're dealing with specifically your medical matters. that you want to make sure you consider the best person to do that, right? You don't want to consider someone who's emotional and can't have conversations or understand conversations with physicians, right? So, healthcare surrogate, designation of healthcare surrogate form is the third tool that you should have in your estate planning toolbox. The fourth tool in your estate planning toolbox is a living will. The living will basically says, if I am in a permanent vegetative state and there's no probability of me coming out of it, do I want to be kept alive by artificial means? That is the living will. So if for some reason you are in a coma and there's no probability of you coming out of it, you want to know, you want to make the decision yourself, rather, whether you want to be kept alive indefinitely for a period of time or not at all. And I say this as an example because I do see it often. You have a loved one who is in a permanent vegetative state, and then you have family members on one side of the bed saying, you know, she's not coming out of it, let her go. And then other family members that say, just give it a couple more days or a couple more weeks, she'll come out of it. We'll see. And so if you've got differences of opinions like that, then you could eventually have people having hurt feelings on both sides because eventually people start to blame each other for whatever happens next. And so that's not something that I would think a lot of us would want for our loved ones. It's also a very hard decision for our loved ones to have to make. So I empower you to make that decision yourself. And just know that not making that decision is also making a decision not to have a living will. But I would encourage you to consider it and have one. I often get asked about this tool, the trust. Now, there's so many types of trust, okay? You have revocable living trust, you have irrevocable trust, you have Medicaid protective trust. There's so many types of trust. And so when we talk about trust as practitioners, especially in this estate planning tool, we're usually talking about one or three of these trusts. And then there's some other trusts that we discuss. But I want to just kind of go through these three trusts with you today. And then, of course, open it up for any questions that you may have. A revocable living trust is just that. It is an entity separate and apart from you. It can also be you. You don't have to get like an EIN number, but it is a document created while you're living that you could put assets into, okay? Meaning you can title your bank account in the name of the trust. You can title a building in the name of the trust. But what makes it unique about or different from an irrevocable trust is that you can change it at any time. An irrevocable trust is a great tool for when you're trying to do Medicaid planning. Um, it cannot be amended. There's always exceptions to that, though, but it's not as flexible in terms of amending as a revocable living trust. And then you also have testamentary trust. Those are trusts that are created through your will. They're essentially happening, or a trust that happens when you pass. I'll give you an example. I have children and I love my children dearly, but I have one in particular that used to have a lot of ideas about how he wanted to come up. He wanted to have a t-shirt business, he wanted to be a gamer, he wanted to have a sneaker business. And so I was a little concerned about him in terms of like what he would do if something were to happen to me and he came into his inheritance. And so what I did was created a trust, a testamentary trust that breaks out the pot of money over a period of time. So he gets so much money a year, and at 25 he gets a third. At 30 he gets a third. At 35 he gets the remaining pot. And that's so that it doesn't hurt him, right? So that's because I don't want him to burn through that money, waste it, and have nothing to show for it. I have had parents create trust for all kinds of reasons, from when you get married, if you complete a trade, if you complete education, or if you get higher education, you get certain grades in school. There's so many reasons to create a trust. And so let's talk more about revocable trust. When are they better? So revocable trust allow you to be flexible, and I think I mentioned that. They do avoid probate. That's not the only tool that avoids probate, but I do want to talk about that. It gives you privacy. So unlike a will that has to be filed in the public record, a trust is not usually filed in the public record. And it can also help you if you're in the event that you're incapacitated. So does a revocable trust help you with Medicaid planning? No, it doesn't. Um, does it help you with special needs planning? So that's if you have somebody that's maybe on government assistance, or they have a special unique ability. Special needs planning trust or special needs trust can assist you, but a revocable living trust may not be able to. So irrevocable trust. Here are some reasons why you would choose an irrevocable trust. We talked about special needs of someone that might have a unique ability. Um, Getting assets or cash directly could probably hurt their government assistance. So we create special needs trust for them. Irrevocable trust, because they're harder to change. You can also, you're essentially controlling from the grave when you pass. So for those that need more assurance that their assets will be distributed the way they want it to be, they would create an irrevocable trust. They also help with Medicaid planning. They're good for estate planning, especially for high net worth individuals or families. And they're great at protecting assets. So when people ask me, why would you choose an irrevocable trust over revocable trust, or which one is better, it really all depends, whatever your needs are. And that's why it's really good to consult with an attorney or professional about your estate planning, because your needs may not be like your neighbors. And so we see a lot on Instagram and Facebook, get a trust, it'll avoid probate. But in Florida, we have so many tools. We have so many means to avoid probate, and trusts are not the only ones. So um, you really want to consider the goal and why you need trust. So we talked about spendthrift trust. That's the trust where you're kind of allocating funds at certain intervals, maybe because you have a son like mine. Special needs trust, also some types of trust. We talked about where you got someone that has special needs or unique ability, and you don't want to ruin their eligibility for government assistance. Trust for minors. There's asset protections trust, standby trust, and trust for guardians of minors. So many different types of trust. So when you hear the discussion about trust, you really want to try to, when I get the calls, or when I get the questions about, I think I need a trust, I always want to know, what is your goal? What's the point? Because if you're trying to avoid probate, we first need to take inventory of your assets. We need to determine what your goals, and a trust may not be the best tool for you. I wouldn't say it's a one size fits all, but they are good tools. Another way to plan and deal with your assets is how you title them. Okay, this is a big way of protecting your assets. I like to tell my married couples that you should own your assets together as husband and wife. You should own your liabilities separate. Meaning, if you have a Capital One credit card, don't both of you guys be on the credit card. Have separate liabilities, joint assets. That way, if an individual in the marriage gets sued, there's no individual assets to collect from. And so when married couples own their assets together, we call that form of ownership tenants by the entirety. So I use that as an example because you might have also heard of a way to title assets with joint tenants with rights to survivorship. Imagine you have a piece of real property and you've got four owners. when you have joint tenants with rights to survivorship, when one passes, the other three owners own it. When the second one passes, the last two own it. And then finally, when that third person passes, this is the only owner. So these three people's children never step in their shoes. It is a good tool to avoid heir property issues, um, if that's a concern. Joint tenants, that's common, mean these four people each own the interest, and when this person passes, their heirs step in their shoes. Whoever their beneficiaries are steps in their shoes. So they continue to keep their one fourth ownership. And then owning something as an individual is just that. Jamie owns this property as an individual. And then there's other ways you can title things. You can title things in the name of your company, in the name of your partnership, your LLC, in the name of your trust. Titling your assets is a very important tool in estate planning. So here are some assets that already have some form of creditor protection. Your life insurance policies, your creditors can never get into them. Okay, it goes, I won't say never, but they don't get into them. It goes directly to the beneficiary. Pension and IRA accounts, college savings accounts, those go straight to the beneficiary. Head of household accounts, disability insurance, and even your homestead your homestead is constitutionally protected in Florida. So unfortunately, we lost OJ, but OJ won his criminal trial, just as an example, lost his civil case, and had a multi-million judgment against him from the Browns. So what does OJ Simpson do? He moves to Florida. He takes his NFL pension and he buys a homestead. And so the Browns are not able to collect because your homestead is constitutionally protected from creditors. And so is your pension account. So these are the many benefits that Florida offers. And so you don't need to worry about creditors coming in and taking those assets. When it comes to your homestead, the only creditors that can get into it is the government if you owe taxes, or the bank if you don't pay the mortgage. And so we oftentimes think that cars, boats, planes are assets. I don't, I think of them as high liabilities. Some would even say high liabilities accidents. How do you protect those assets? And should there be an accident, how do you protect the asset that other creditors could reach, like your rental properties, your real estate investments, your second home? Make sure you have proper insurance. Also, titling the asset is important too. So we talked about forms of ownership. That's all about titling. I like to encourage my parents and my married couples. If you have a car that someone else is driving, make sure their name is on that title. In Florida, cars are considered dangerous instrumentalities. And while we're no fault state, people do get sued for car accidents. And in Florida, you can be sued for the driver can be sued, but so can the owner. And so you really want that teenager, if possible, to own that car or have really good insurance on it, right? And I know that can be expensive, but that's the way to protect your assets, because while your homestead is protected, I did not say that your bank account is, right? And so your investment real estate is not protected. Um, Typically. But if you title it in such a way, it can be. So if you have it in the name of a company and not your individual name, then you can protect yourself, your individual assets. Same if you have it in a family limited partnership. If you own the property with your spouse, titling it that way is also a form of protection. And then, of course, having proper insurance. So, again, another example of why titling is a part of your estate plan, and it's one of the very simple ways that you can protect your assets. So insurance, I'm not an insurance agent, but insurance is also another way to protect your assets. I know insurance can be expensive, but of course, having life insurance, health insurance, disability insurance, insurance can be a way to protect your asset. And your biggest asset is your health. And so having adequate health insurance and then other insurance can help you. Now, if you own a business, definitely consider having some um, liability insurance as well as some malpractice insurance. So everybody has a bank account, I'm sure, on this call. Um, Here's a very simple tool that you can utilize with your bank account. Make sure you have what is called a pay on death beneficiary. And this is so important. We recently have a case where unfortunately someone passed away and they hired us to do a formal administration. It's a type of probate. There's summary administration in Florida, and then there's formal administration. And they end up paying close to $4,500, only to find out there was nothing in the bank accounts. And so that could have been money that they could have kept, to themselves and for their families, and something that the decedent could have planned for too before they passed, by just going to the bank account and adding pay on death beneficiaries. All that beneficiary would have had to do was take the death certificate, and which is about $6 to $10, and their ID, go to the bank and retrieve the contents of the bank account, or found out that there was nothing in the bank. Instead of having to hire a lawyer to do what's called formal administration and have a personal representative appointed to go and look into the bank account to learn there was nothing in the bank account. So if you're on this call, I don't think it's any coincidence that you're here today. I want you to add pay on death beneficiary designations to your bank account. So you can go to Wells Fargo if you're banking with them. You can go online, Bank of America if you can go online, and you can add pay on death beneficiaries to your bank account. Not owner, but pay on death beneficiaries. And I caution you about adding people to your bank account for convenience, because then what could happen is if they have a debt out there and they get sued and a judgment is imposed on them, then that creditor sees your bank account as theirs too. So be careful about adding owners, people as owners, to transact business for you, but do add your loved ones as your beneficiary so they can get the funds. For me personally, I have minors, so, and then I have grown children, but I have my trust as the beneficiary. So if something were to happen to me, the trustee can go and collect those funds and put it in that pot for my minors or for my children. Another thing you want to be, you look at all your financial accounts. So your bank accounts, but look at your pension, your annuities, your life insurance policies, and double check, occasionally who the beneficiary is. As life happens, as our circumstances changes, as people come in and out of our lives, we might want to update those. And so I want you to occasionally go back and see who's on your life insurance policy as the beneficiary. Should you change that? Who's the annuity beneficiary? Who is the pension beneficiary? Any of your financial accounts, your CDs. If you own stock, see if you can add beneficiaries to it. That will avoid probate. And so the final tool that I want to talk to you about are deeds. Deeds relate to real property. If you own real property, doing a deed during your lifetime will avoid probate. Typically, there's two ways to give property away: by deed or by court order. And so when you pass and all you have left is a will, well, your loved ones still have to hire someone to probate the real estate. The will says where I want my things to go, but it doesn't necessarily avoid probate. So doing a deed during your lifetime could avoid probate. And one of the tools that I like to use when I'm doing estate planning is the ladybird deed or the enhanced life estate deed. That is a deed that essentially says, I own this property and I'm giving it from myself to do whatever I want with it. And if I pass and still own this property, it goes to these people or this person. And it goes to them without having to do probate. And so all they will have to do is have my death certificate recorded to get the property. They don't have to hire a lawyer. So you see, we've got all these tools. And just like when you have a toolbox, you have a hammer, you have a screwdriver, you have a wrench, you may not need to use all of them. You may need to use some of them. Knowing what you have, how you have it, how it's titled, where you want things to go, and your goals helps us to determine what's the best tool for you. And so I want to open it up to questions. If you have any, feel free to take yourself off mute. I don't know if you can. Okay, so I don't see any questions, and that's good. That's okay. I don't know if you can raise your hand too, if you're able to raise your hand. But if you have questions, please raise your hands. Um, and I'm happy to answer them. But and I don't see any, but I do want to extend an offer to the first 50 people for the month of May. It is Mother's Day. I do intend on having a Father's Day special as well. But if you are interested in estate planning, we're offering a free consultation for up to 30 minutes. And then we are taking a huge discount off. We can only use the chat. Huh. Um, okay. If you have a question though, I probably can undo your mic though. So I don't know. No. Interesting. Okay.
Check.
Oh, I can hear you.
Okay, cool.
Okay. Well, please put your questions in the chat.
I do got a question.
Oh, go ahead.
What was the third thing to the will? The first two was like, how will I be buried? And then who will carry this out? Then there was a third part.
Right. So the first thing is, how do you want to be buried? So let's just say you have a special burial plot or you want to be cremated. Um, Putting that in your will is going to be helpful. And if you don't want to put it in your will, I would encourage you to have um, all your burial stuff together with your will. So, and then put these documents in a fire resistant waterproof box. And you can get those from like Walgreens or kind of like a safe, CVS. But the first thing is, how do you want to be buried? The second thing is, who do you want to serve as your personal representative? A lot of times I get people, they're confused, oh, she's listed as the personal representative. The personal representative is not the beneficiary. The third thing about your will is, where do I want my things to go? That's who the beneficiaries. Where am I leaving my things?
Okay. That's what I needed. That right there. And I had another one. My bad.
Go ahead.
And you were saying to set up the trust to designate it as a beneficiary, is that just a document or is that like a legal process to have? How do I set up the trust to do that?
So you want to create a trust. And I'm so glad you asked this question because it kind of makes me think of another situation, but that I'll share with you. But when you create a trust, it's really a document. I like to also think of a trust as a box, a nice, pretty, box, really expensive box to create. Um, but you have to put things in it. Okay. So when I say you have to put things in that box, I'm talking about you have to title assets in the name of the trust to really have a trust. So I have had a case where they had a very elaborate document that was created by them that had all the decedent's wishes spelled out. I want $50,000 to go to this grandchild. I want $1 million to go to this child. I want this home to go to this girlfriend. Just all of these really nice, elaborate gifts were laid out in this document, but nothing was titled in the name of the trust. The life insurance policy was titled in two kids' names. The house was still in his name. The grandchildren didn't get the money because the way the assets were titled, they were still in his name or they were in two other people's names. And so what happens is if I have a 401k policy and it's not titled in the name of the trust, or I don't designate that as the beneficiary, the trust as the beneficiary, then whoever I have named to get the funds is the one who gets the funds and they don't have to share it. So when I say title things in the trust, it's not a legal process, but it might be as simple as, here goes my Bank of America account. It's titled in the name of the trust to the trustee of Jamie Coleman's last will and testament dated blah, 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 Descendants Trust. And so having that title, that designation is how you put the asset into the trust. And if you never do that step, then you can have this really nice document or box that you created and nothing in it.
Oh, so like where you leave the beneficiary, like an actual, like someone's name, you would put the trust.
Right. And the
Okay.
beneficiaries are listed in the trust document, right?
Okay, cool.
So you'll say, this is the trust of Kendall's family, dated this date. This document says, here's the beneficiaries of Kendall. These are the conditions that the beneficiary gets the funds or the property. And only when these conditions are met do they get it. And hey, trustee, you have to make sure that they get it. But then you go to the bank, you go to the life insurance company, or you put on your deed, this asset is to be paid to this trustee of Kendall's Family Trust, dated blah, blah, blah. And that's how you title the asset in the name of the trust.
Okay. It's a question in the chat, I think.
Okay. The question is, hey, Jamie, thanks so much. If one has a home that sits on air property, what do you suggest them do to what do you suggest that they do for leaving or willing a home but not the dirt? All right. So if you have an interest in air property, I would still make mention of where you want that to go in your will. You may not be able to deed your interest if your name is not on it. So air property is when two or more family members own the property together or have an interest in it. A lot of times, especially around these parts, we see that property is owned in the deceased person's name and their beneficiaries or their children and their children's children have an interest, but it's still in that person's name. If it's still in a deceased person's name and you haven't probated it or you haven't done a partition action or any type of lawsuit to designate that you have a title, a record title interest, you may not be able to deed that interest during your lifetime. But you can will it. You can say in my will, hey, I have an interest in this air property. I want to make sure it goes to this person or these people. So whenever the air property is eventually dealt with, they'll see in the public record, because remember, your will gets filed in the public record where your things go. So they'll see who gets your interest in the air property. The other reason I want to encourage everybody to have a will, even though it doesn't avoid probate, is because when you don't have a will, Florida has one for you. I'll be very candid. I have um, four children, and so every child has a different father. So imagine if I was this very well-to-do, very public persona, and I passed away, and there was a lot of money to be had for my children. You could probably see the fights between their parents, their other parents, about who gets to handle my estate for their children, right? This is such a common issue. I mean, whether you're wealthy or not, this happens. Um, and so when you have a will, you're then dictating who's going to serve as your personal representative and where you want your things to go. When you have minors, you can also say who you prefer to be the guardian and the guardian of your child's property. While a guardian is a process that the court is involved in and they ultimately decide the guardian, they will consider your wishes. So you definitely want to have a will, because when you don't have one, Florida will create it for you. Now, I have some parents out, not parents in the sense that they're caring for other people, but maybe they don't have their own biological children. And so they pass away. Well, guess what? Their siblings may get their property, or their parents may get their property. And imagine if you have a parent that hasn't been active in your life, then they may still get your assets by virtue of Florida's intestate statute. So, again, when you don't have a will, Florida will leave one for you. And you may have to put your questions in the chat because I am having a hard time disabling or allowing the mic. Miss Robinson, did you have a question? Can you hear me? Can I hear you? And then Allison, I'm gonna try to allow your mic, but if you don't mind, let's see. Can you speak? Can you talk? I don't know if I hear you.
Jamie, can you hear me?
Yeah.
Okay, I have a question. So a lot of times I hear people say like, "Oh, this is going to take forever. I don't have time." Can you walk us through like what is really like the time frame to get something like this all set up?
It really depends on you. Um, so typically when I do estate plans, I promise your draft within 7 to 14 days, within 2 weeks. And so you review your drafts, and whenever you're ready to sign, you're welcome to sign. This does not have to be a long process. And if it's a really simple plan, it may not even take that much time either. So it really depends on you. I will say, I don't think it's any coincidence that we're all here tonight. So if you don't have a will, definitely consider having one, and definitely consider having a power of attorney. But this doesn't have to be a long, drawn out process. And that's all a matter of perspective. There's so many reasons why people don't have an estate plan. Oh, they put it off. I'll put it off until later, when then later comes and they never do it. Or I don't have enough assets to do an estate plan. Or I don't own anything, or I don't have anyone to give it to. I think that, we can all come up with reasons for why, or it takes too long. But these things really can move at your pace. So it doesn't take long. I think the first step in doing your estate plan is you first taking inventory of all that you own. So look at what you own, write it down. I have this car, I have this property, I have this bank account. And so another thing is, I get people that'll say, well, I don't own any property. I'm still making a note. I'm still paying the mortgage. well, if the deed is in your name, you own the property. You may have to pay a debt to keep the property, but you own it. And so you need to include that, because the debt, if it's gone away, then who gets the title to that property? So many reasons why people don't do an estate plan, but these things do not have to take long, especially if your plan is simple and it really can move at your pace. Thank you for the question. Allison, are you able to
for the answer.
talk? Okay, so I can't, Allison, if you don't mind putting your question, I'm not sure why I can't undo your mic, and I really apologize for that. But I did get an, and I don't know if you could try, Allison. Can you try now? Um, I did get another question. It says, hello, Jamie, thanks for this mother's legacy. I'm very grateful now. Is it better to have a trust and you still need a will? Okay, so Miss Walker Palmer, thank you for your question. It really, I'm going to give you the lawyer answer. It really depends, okay? Again, I want you to take inventory of everything you have and how you own it. And then what's your goal, right? So let's say, for example, let's just say you have a home, and I think she left, but let's just say you have a home and you also have a bank account. And those are the only assets that you have, okay? Your home, you can do a ladybird deed or an enhanced life estate deed for your home if your goal is to avoid probate. You can put a beneficiary designation on your bank account, and those two things will avoid probate. That's if that's your goal. But let's say your goal is, I never want this home sold. I want it to stay in the family forever. And I want whoever lives on it to pay the maintenance, the property taxes, the insurance. Well, now you're controlling from the grave. So I like to think sometimes as trust being a fist coming from the grave, I am controlling from the grave. And so in that case, you might want to have a trust, because then you can impose these conditions even when you're no longer here. And people will have to follow them in order to benefit from the asset. So it depends on your goal. It's not one is better than the other. We have to know what you have and what your goal is to say, this is the best tool for you. Hope that answered your question. Allison, I see your hand raised. Do you think you can put your question in the chat? Okay. Well, if anybody else?
Yes.
Okay.
Can,
Okay, I
can,
think all mics might be disabled now.
what do you mean by how do you own it?
What do I mean by how you own it?
Yeah, you said like list your assets and how you own them.
Right. So let's say you have a business and you have a piece of real estate. Say that that real estate is titled in the name of the business. So it's Kindle Enterprises LLC. The how you own it is the titling. Your bank account, if it's in your individual name, that's how you own it as an individual. It's in Kindle's name. Let's just say you and I both have a bank account. Well, then it's in Jamie and Kindle's name. So how you own it is how it's titled. Is it in your name personally? Is it in your name with somebody else's name with joint tenants with rights of survivorship? Is it in the name of your marriage, Kindle and so as husband and wife? Is it in the name of your company? How you own it means really and truly, how is this asset titled?
Thank you.
No problem. Okay. I don't see any more questions. So, so, I do want to give you guys this special offer because you're in attendance. And the offer is really, you get a free consult with us for up to 30 minutes. We send you your intake form, you complete it. That's the form that says, hey, this is what I own and how I own it. Um, and so this is if you decide to sign up by the end of the month. And then also for our dads that are on this call, we'll have another seminar, but just if you don't want to attend it because it's the same information, you feel free to take advantage of the discount. Of course, if you have any questions, I'm happy to answer them while we're on the call. Um, and I appreciate everybody attending. I know, Ms. Robinson, it looked like you had another question. Is your mic on? Hmm, terrible.
Right quick, for people that type all this out, does it need to be notarized, or like what makes it official?
Yeah, so there's formalities. When you do your will, deed, trust, there are formalities. And so your will has to have two witnesses and it has to be notarized. The same with your deed. Your deed has to have two witnesses and it has to be notarized. So when you don't meet those formalities, then it's not presumed valid. Well, again, it's been my pleasure. I'm really sorry about the Q&A um, situation where the mics are not on. I think you probably are supposed to put your put your questions in the chat. I think that's probably how it's set up. Miss Gwen is typing a message, so I'll give her a minute. Oh, you're welcome. Thank you. Oh, it's my pleasure. And so if you have any questions, you're more than welcome to reach out to me. Happy Mother's Day to all the mothers. I really appreciate you joining this. Any feedback you have, please feel free to give it to us. Um, Happy to, take your feedback. And yes, happy to send the recording. I did get a really good question. Are the notary and witnesses included? What does that mean when you do your estate planning with us? Because we notarize and witness everything. Most attorneys do that. They already provide the notary and witnesses. But if you're doing it yourself, then you definitely need to have two witnesses and it has to be notarized. Miss Gwen, I think, is elaborating on her message. Yes, so when you do an estate plan with our office and with any attorney, they typically provide the notary and the witnesses. So everybody in my office is a notary. So, including myself. So when you sit at the table with us to sign your documents, you have the witnesses and the notary. Well, thank you again. It's been my
The
pleasure.
mics were disabled, were enabled.
Oh, they were?
Yeah, so Allison might be able to ask her question.
Okay, Allison. Okay.
Hi, Jamie. I think
Hi.
hi. So I just had a question regarding the beneficiary versus like the spouse. Like, how does it work if you have a spouse and you have someone else as the beneficiary on the properties or account?
It goes directly to the beneficiary. And
Okay.
it really kind of depends on the type of property, right? So in Florida, if you do a ladybird deed or an enhanced life estate deed to your homestead, and your homestead is shared with you and your spouse, if they're not the beneficiary to the deed, they still keep a life estate interest, meaning they can live on that property for their lifetime. So even if you don't name them as a beneficiary to the deed, they'll still be able to live on it. But when it comes to your financial accounts, like your bank accounts, your life insurance policies, your annuities, your pension, if you have somebody else listed as a beneficiary, your spouse doesn't get it, right? So I have adult children and I will be wed soon. So my children are listed as beneficiaries to most of my accounts. That's who will get it, just regardless to whether I'm married or not, because they're listed as beneficiaries or the trust is listed as beneficiaries. Great question.
Okay. I think so the price that you listed, is that just like Florida based or like is it more for out of state or how does that work?
So I'm not licensed in any other state but Florida. So if you need an estate plan and you're located in another state, now you can have a Florida estate plan, but if you have real estate in other states that don't have the type of tools that Florida have, like the homestead protection tool, like the enhanced ladybird deed, I would refer you to uh, uh, someone in your state that has those that has that expertise. So, but the United States gives full faith and credit to wherever you have a will at. So if you got a will done by a Florida attorney, if you're in California, California will still accept it. So a lot of times people think, oh, I'm moving. Do I need to get another estate plan? Not necessarily, because wherever, if your circumstances hasn't changed and the people that you want in these positions haven't changed, then whatever state you move to will still give full faith and credit and treat your will valid if it was done in another state. But if you own real estate, then I would want you to be in touch with someone that has expertise in estate planning for that particular state. And I'm happy to refer you to someone.
Okay, thank you.
Of course. I think the mics are off. So are there any other questions? Okay. Well, again, I appreciate you guys for joining us. You can reach me here at Jami at Coleman.law. You can also visit our website at Coleman.law. And you can also give us a call at 850-688-8651. I will put all that in the chat for you. But I really appreciate everyone attending. Please take care of your moms, take care of their legacy by encouraging them that if they don't already have one, to have an estate plan. And with that, you guys have a good evening and y'all be blessed.